Hello and welcome to the Legal Eagle this week. Joining us on the show this week is former Solicitor General of India, one of the country's most popular Supreme Court lawyers. He's also someone who's been an amicus in very famous environment cases for a long time, for which he's been praised by the top court. Joining me today is Ranjit Kumar, Senior Advocate of the Supreme Court. Mr. Kumar, as I welcome you on the show, I want to first ask you the question and your long association with the environment cases where there's been sealing, illegal construction. The Supreme Court tried to offer you 50 lakh rupees for the amicus work that you had done in those cases, and you had very magnanimously refused that. Take us through how you have been a part of those cases and benefited the environment.
Well, it is like this, that I was first appointed as an amicus curiae for cleaning the Yamuna. There was a article in a newspaper called the "And Quiet Flows Maili Yamuna." That article was taken suo motu cognizance of in the year 1993, if I remember correctly, and I was appointed amicus in that case for the purpose of how we could go about cleaning the Yamuna. So that matter went on for a very long time. A lot of work was done. A lot of sewage treatment plants were set up under orders of the court, and cleaning process had started, and then came the second phase of it, etc. And the matter was ultimately transferred by this court to the National Green Tribunal. And since then, after its transfer, I am not aware as to what all has happened there. But that was the first matter on environment that I was appointed amicus. I had been appointed earlier amicus in other cases which were not environment related as such. Thereafter came this MC Mehta matter. This has several aspects, including the Aravalis and the forest in the ridge. So the ridge area was forested and it was being deforested, and colonization was happening, and Aravalis were being degraded in very many ways. So the judgment in Aravalis came, first judgment came in 2004, thereafter several other judgments came, and the last judgment came in 2018, whereby some demolitions have also been ordered and have taken place. So Aravalis, the preservation of Aravalis, because it protects Delhi from its desertification. It's a mountain chain, one of the second oldest mountain chains in the world, and it prevents desertification of Delhi. Therefore, it was an important aspect. And how the water which goes through in the rainy season through the aquifers inside and gets collected, which is called the groundwater, the groundwater reserves were depleting, and they have now revived to a very, very large extent. So that was the second aspect of the environment. And the third aspect then was of illegal industries which were running in Delhi. Even unauthorized constructions were included. Though, of course, Supreme Court has now held in 2020 that it is not the part of the monitoring committee to deal with those unauthorized constructions, and the department must take note of. So that is another aspect whether monitoring committee can do or not. But the MC Mehta matter which I was assisting was also to this extent that all unauthorized constructions should be checked, misuser of premises must be checked, unauthorized industries must be checked, and they must be closed down. So that is the part of environment that I have been dealing with.
This is marvelous, because I've seen Mr. Kumar, that's marvelous. Mr. Kumar, I've seen you've been an amicus in several cases. I've seen you've been a part of the Sohrabuddin Sheikh cases. You've been a part of the Gujarat riot cases. You've been a part of the Sabarimala case, Article 370. You've represented Tamil Nadu's former Chief Minister J. Lalita. You've been an amicus in several cases. I wanted to ask you, according to you, which have been the most impactful cases that you have been a part of?
Well, it's very difficult to say in my 40 years of my career as a Supreme Court lawyer as to what would be impactful. But I would say my first very big case which I did was the case which was also an amicus case, where children of prisoners were required to stay in the prison, especially the mothers, because the children were of tender age. So I informed the court and requested that it can't be that only because the mother has committed a crime and the child is of a tender age which goes up to 4 to 6 years, the child must also stay in the prison. And that it should not happen that the child must be brought up in that environment. On the basis of my plea, the Supreme Court passed judgment saying that if the child cannot stay at home because there is nobody to look after, and because the child is of a tender age and therefore he can't be without the mother, then you must build something which is maybe near the jail, where the children can be brought up in an atmosphere which is not jail. Because if the children were to be brought up in an atmosphere of jail, they would be, affected by their mental psyche and later on may turn out to be not very good citizens. So that was accepted and reforms were made in all the jails that children cannot be kept in jail. They have not committed a crime. Their mother has committed a crime. Their father has committed a crime. But that can't affect their life. They have their own freedom. So that was one of the most impactful cases which I feel I have done so that children should not suffer.
Absolutely. And it's very heartwarming to have heard that, because as a mother I can relate to that. And Mr. Kumar, I actually started off the question by talking about very influential cases that you were a part of. You actually went to something that lawyers are actually known for: service to humanity. I also want to ask you, I remember very interestingly, and I want to know about in particular, you've had a lot of friendships. One, of course, has been with Mr. Arun Jaitley. In 2005, I remember there was an incident, yes, and we all know how there were walks that you used to take with him at Lodi Garden when he had been unwell, and how you had driven him to the hospital. You had you'd driven on the wrong side, how there was this particular time when you had saved his life. I want to know about that friendship, how it started, and what was that incident about?
In 2005, we had come for the walk there itself. It was not Lodi Garden. And he suddenly, just about 200 yards away from the entrance, he started feeling very uncomfortable. So, and coughing very badly. So I said, there's something wrong. So he said, yes, something is wrong. So I put him in the car, and he said first he wanted to go home. So we drove home, and then from the home he said, no, I have to be taken to a hospital within 2 minutes. So we drove from his Kailash Colony residence to Escorts in New Friends Colony, and that was in the early morning. It was July, so it was around 7 o'clock. Traffic was less, fortunately, but on the way we could make 2-3 mobile. The mobile was very, very handy. We could make 2-3 calls. I called up his wife. I called up the Dr. Trehan. I called up 1 or 2 more people. So we reached the emergency ward there, and we shouted about an emergency, and they came, and things were brought under control. But one thing that still affects me is that the fact that he was in such a terrible state that I was able, in the sense God was able, so I am nobody, I am only a messenger, that he was all right.
Yes. Mr. Kumar, you mentioned being the Solicitor General. This was in 2014. You became the government's second most important law officer. It happened at a time when the government had just come to power. In 2017, you resigned citing personal health reasons, is also family obligations. That was, I think, around Diwali on 20th October 2017. This was also around 3 to 4 months after Mr. Mukul Rohatgi had resigned from being the Attorney General. What were in hushed corridors of the Supreme Court, several reasons were being given for this. Was there any discontent at that time that you had resigned? What were the actual reasons for your resignation, sir, when in fact you had been asked to continue?
Yes, in fact, the law minister was kind enough to call me several times that I should reconsider. I must tell you that my mother was keeping very ill after my father's death. My father died in 2015 while I was arguing before the Constitution bench of Chief Justice Dattu, a very important criminal matter, as as the Solicitor General. And after my father's death, my mother started keeping very unwell. And in 2017, she took a turn for the worse. And I owed a duty, because being the only son, I owed a duty to look after her. And that was the only reason why I resigned. There was no other reason ever. And the government and the officers and the department and the other law officers and the Central Law Agency, everybody was always very nice.
I take your word for that. I also want to draw your attention to 2016, Mr. Kumar, when we remember there was a resolution that had been passed and there was a lot of chaos that had happened in the Supreme Court corridors at that time. I also remember a resolution being passed against you, P.P. Rao and Mr. K.K. Venugopal. And at that time when that resolution was passed, Mr. Salve in fact had represented you in the court, and he had to have 9 policemen come and move out of that courtroom. So there were 9 policemen who escorted him out. What was that resolution all about? Over the past few years, have you seen there is a sense coming in from the Supreme Court? There's a certain lobby that is trying to besmirch the reputation of the judiciary.
You know, in every case or in every matter, there are always two sides, and it is the judge's duty to decide the cases they consider it fit. So you can't say that it is my way or the highway. So that is the perception which I think is going around, when they say that because my view has not been accepted, therefore something is wrong. That is something which should never be part of the judiciary, and that is really the cause for bringing about our own institution, where we have to go every day, we have to defend people, we have to to take the law forward, and we should be endeavoring more about justice than about our own perceptions about any matter, because we feel that that matter goes by my perception rather than by the law and the record of that case.
Absolutely. I also wanted to ask you, Mr. Kumar, very important cases that you've done that concern Jammu and Kashmir, whether it's the pellet guns case that had caught the attention of the nation, or whether it was Article 370 cases that you were a part of in the Supreme Court. These cases laid the law of the land. It's very critical today that when we talk about Jammu and Kashmir, it was the path-breaking judgments of the Supreme Court that helped in that. Take us through what you believe to have been the stone mark, the most important part of these cases when you were arguing them in the top court.
Well, insofar as the rubber bullets are concerned and their use, the officers who had briefed me and shown me the data on it, and which we presented to the court, it was very clear that apart from dissuading people from raising the kind of dharnas or the kind of agitation that was going on, that to control that, except that there were 1 or 2 stray injuries. Otherwise, by and large, 99% of the cases, the rubber bullets that were used were not of such a nature that would cause a permanent damage to any person. So that is something we presented to the court, and we also informed the court that the use of those is in the last resort. It is not that at the first instance itself, those bullets have been used by the forces to quell the mob, if I may use that expression. That is first part. So far as Article 370 is concerned, I had raised an issue that somebody who had settled in 1950 or 51, and because they were given government jobs, because the local establishment did not have people who would take those jobs, they came from nearby places of Punjab or otherwise, and they were given jobs. Why should their children suffer in terms of a deprivation that they can't get college admission to medical or engineering colleges? They can't represent the state in sports. They were good sportsmen, but they were not allowed to represent the state because they were not treated as residents of the state. They can't be allotted plots of houses or houses within the state because their father was not a resident, and that resident status took away that their status of having been brought up from birth to their age, whichever, say 20, 25, they will not be given jobs, they will not be given medical admissions or engineering admissions, they will not be given represent the state, or they will not be given houses. That was something which I brought to the notice of the court, and I said that this is violative of the Constitution, and that writ petition was accepted in the sense that it was admitted. But then thereafter, 370 having been abrogated, that petition is still there, but because of its abrogation, it may not be the same situation today. That was my argument challenging Article 35A, because what I informed the court was that 35A is not in the printed volume of the Constitution. So the judges took out the Constitution and had a look, and they found 35A is not printed. I said, how has it, the judges asked me, how has it been brought about? I informed the court that it is only because of the J&K constitutional order that 35A stands inserted, and that is, it will be only found there and not here. So having found it in that manner, therefore the judges were kind enough to issue notice in the matter and admit the matter.
Mr. Kumar, I also want to take your attention to the Sabarimala case that you've been a very important part of. We remember how right to equality has been a movement in India for women, whether it was the triple talaq cases, whether it was the Shani Shignapur case, whether it was the Sabarimala case where we saw religion versus this debate on women's equality. You were a part of the bench that was you were a part of the lawyers who were a part before the bench, and you were along with Mr. K. Parasuran in this case. Take us through what you think is really the pertinent issue here that needs to be coming forward when it comes to the Sabarimala issue, sir.
Yeah, let me just correct a little bit on facts. In the Sabarimala case, I have been instructed to appear when the matter stands referred to 9 judges, and the questions have been framed by 9 judges. And so I addressed the court at that point of time. Yes, in the earlier, when the main judgment was rendered by the Constitution bench, I was not representing anybody at that point of time. Now, the second aspect is that when the Sabarimala 9-judge bench took up the hearing, the issue involved is about 2 judgments, earlier judgments of this court, and basically the right to profess one's own religion in a manner known to its system of customs and practices under Articles 25 and 26. Now, that is the very important question, whether a person enjoys that right to practice their religion, or a sect of persons, a set of persons, or a congregation of persons, or a larger community of persons can practice their own religion in a particular manner by a set of customs and practices, is the very important question. Can you raise the issue of equality when you are going into religious practices and religious customs? And if the religious practice and custom from time immemorial does not allow something to happen merely because there is a right to equality, can that be distinguished? That's the issue on a bare reading of Articles 25 and 26 and the earlier judgments, the basis of which the matter stands referred to 9 judges.
Today, we're seeing a massive effort that is on Article 19(1)(a). We're also seeing, on the basis of tweets, action is being taken by certain state governments, whether it is in the state any state, no matter what, we are seeing certain action being taken. We've seen the Supreme Court come out recently, Mr. Kumar, in a judgment in which they've said deprivation of liberty for even one day is a day too many. They've clarified this in a case where our editor-in-chief Arnab Goswami had been arrested. The larger picture when it comes to liberty, the law of the land in India is clear. It has to be maintained when it comes to human rights. The high courts have to keep their doors open, and it's a very clear message to the state governments also: do not use criminal law as a weapon. How do you look at this particular new the judgment that has come and this particular law that has been a part of India for very long?
Well, let me say first of all that the Honorable Court has reiterated the settled principles of law, such as that bail and not jail is the core of our constitution. One must get bail, and it should not be that one should be in jail, and that the trial courts or the high courts must be conscious of this fact that the rule is of bail, the rule is not of jail. So there has to be very, very good grounds to say that no, you must languish in jail. That's the first part. The second part is that freedom of expression and speech has been recognized in our country since the time of our constitution having been brought into force in the year 1949 November. So I will put it this way, that any dissent is not something which you should try to cut at the root. The dissent is a part of our democracy. Anybody saying anything, any speech should not be taken to heart. Why should you immediately take something to heart because I say something against you? You should not. You should allow such person. There are all kinds of person. We have 130 crore population. Now if we start, telling everybody that no, you shut up. Why are you talking like this? You should not talk like this. You must only toe one line. You should not show a dissent. That's not a correct attitude. Dissent is a part of life. I may have a different view than what you may have. So I can say something different than what you say. But that different view of mine, which does not match the other's view, is not a dissent. That is only his view. It is his perception. So he is expressing that perception. If a person expresses such a perception about a thing, that does not mean he becomes anti, that he doesn't become anti-you. He doesn't become anti and think that, oh, he's taking cudgels with me. He's not taking cudgels with you. You have a view, you respect it. I have a view, you must respect that too.
Yes. It's been wonderful chatting with you, Mr. Kumar, and the best thing I liked is I've thrown a volley of questions at you, plethora of them, immediately, spontaneously, you've been able to answer them all, and that's what a really good lawyer does. I thank you for being with us on the Legal this week. It's very profound to know how you've been able to cover all the aspects that I mentioned, and it's been a pleasure. Thank you for watching in, viewers. See you next week. Thank you.
Thank you.